In this module, we're going to take a look at the doctrine of stare decisis and briefly look at what legal reasoning is. Let's take a look at what a precedent is. So when possible, judges have always attempted to be consistent in their decision-making process. They want to base their decisions on the same legal principles that they did in earlier cases or that were suggested by other courts in other cases. And every time they considered new cases, they did so very carefully because their decisions made new law. Each interpretation by a court became part of the law on the subject, and it served as a legal precedent. So a precedent is a court decision. It will be a written opinion today that furnishes an example or authority for use in deciding subsequent or later cases. And we're not talking about every case, but those cases that have facts that are very similar. So a precedent is important for you to know. Now, to be fair, not every Court of Appeals decision does create precedent. We have opinions that are published. Those typically have new precedent, and those that are unpublished, at least in Texas, and the unpublished opinions don't really serve as precedent. They articulate something, but it's nothing new that's being created. It's just applying past precedent. So where is this precedent found? Well, in the early years of common law tradition, it wasn't really a good place. Now there has been for, at least from my point of view, for forever. We have reporters. Now, a reporter is not someone who works at a newspaper. A reporter is a volume. It's a book that is a place where all of the written opinions, the published opinions, are collected in order, and then they make books and print them so that lawyers and judges have access to them. Now today there's also electronic resources where there's electronic versions of these two, but in Texas we have the Southwest Third now Reporter, and that's where our cases are found currently in 2020s. So stare decisis is a doctrine, and it's a common law doctrine, so this is not a doctrine out of the Constitution. This is not a doctrine out of some sort of statutory framework. It's out of the common law. So this is a practice of deciding new cases with reference to former decisions and legal principles. And the idea that you must follow precedent is this idea of stare decisis. So it's a common law doctrine under which judges are obligated, that is, they must follow the precedents established in prior decisions. Under this doctrine, the judges are obligated to follow precedents established within their jurisdiction. So a Supreme Court in Mississippi, even applying stare decisis, doesn't really have any sort of pressure on a Texas court because Mississippi is not in a Texas jurisdiction, right? It's a different state altogether. Whereas the Texas Supreme Court, if it decides a case, there's precedent, it controls all Texas courts. Same with the United States of America on matters of, let's say, United States constitutional issues. When the Supreme Court of the United States has a decision and it has precedent, it's binding on every court insofar as there's a constitutional question that comes up. Stare decisis, for you need to know two aspects. The first is that a particular court should not overturn its own precedents unless there's a really, really, really good reason. Generally, they should not overturn their own precedents. And then second, decisions made by a higher court must be followed by lower courts. They're binding on lower courts. So the 14th Court of Appeals in Texas, there are 14 courts of appeals. 14th Court of Appeals is in Houston. If the 14th Court of Appeals decides a case on January 1st, and then on February 1st has almost identical case, it must apply the same law. It has precedent. It must follow its own precedent. Similarly, if on January 1st, the Texas Supreme Court decides a case, and then on February 1st, the 14th Court of Appeals has a case, it must follow the Texas Supreme Court's precedent. This is stare decisis. There are different kinds of law and authority. Some authority is merely persuasive, but some authority is binding. Binding authority is any source of law that a court must follow when deciding a case. Now, you would definitely want to use the appropriate tone in court when you're talking to a judge, but if you have binding authority and the binding authority is on your side, this is the one time you can actually tell a judge, you must do X, you must do Y. You obviously use the right tone. You don't want to have a bad attitude. Don't mean anything like that. Not going to be smug or cocky, but you can tell the court, Your Honor, this court must do X. Not because you say so, not because you think the judge wants to do it, but maybe because the Texas Supreme Court has said so. So if you have binding authority, it's very powerful. Whereas persuasive authority is less powerful. Imagine you have a case of first impression. That is, a particular court has never decided a case like this. Let's assume that no court in Texas has ever decided a case like this. It's a case of first impression. You may argue that the state of Louisiana has considered a case like this, and this is how they decided it. The state of Mississippi has decided a case like this, and this is how they decided it. You could look to New York, you could look to Delaware, you could look to the federal circuits. It's persuasive authority. And what judges could do is say, well, we really like the way the state of Mississippi handled this. We don't actually think Louisiana got it right. So we're going to adopt the same legal reasoning that Mississippi used. And now, once they do that, that becomes Texas law. So persuasive authority is any legal authority or source that a court may look to for guidance, but does not have to follow. This could be precedents from other jurisdictions. It could be from a law review article. It could be from counsel herself. Persuasive authority, sometimes lawyers write articles, they write books, they write book chapters, they give presentations. So it could come from anywhere. Typically, it's going to be a law review journal. It's often going to be precedent from another jurisdiction. So now let's take a look at what legal reasoning is. What does it mean to say that the judges have a process of legal reasoning? So in deciding, number one, what law applies to a given dispute, and then applying that law to the facts or circumstances in a given case, judges rely on the process of legal reasoning. Legal reasoning is the process of reasoning by which a judge calibrates or harmonizes his or her opinion with the judicial decisions in previous cases. So we're going to take just a quick look here at IRAC, the Issue, Rule, Application, or Analysis in Conclusion method, the IRAC method. This is not something that is new and improved. This is tried and true. Every law school student in the nation, all lawyers, all judges use IRAC. Some use CIRAC, which adds a C, and it starts off with the conclusion, and then the issue, the rule, the application, and then conclusion again, but it's all the same. Issue, rule, application, and conclusion. You must spot the legal issue. You must know what the law is and which laws apply. That's the rule. Then you must apply the rule, the law, to the given facts and circumstances, and then you must come up with your conclusion. Issue, rule, analysis, and conclusion. So the issue, how do you figure out what that is? Well, number one is you have to know the law, but you also have to understand what's going on in a given situation. And in a court case, you get that through evidence. If a client is coming to your office, you would get that generally from your client telling you a story. So what are the key facts and issues, the legal issue? And then, well, what rule applies? Is it employment discrimination law? Is it a Texas constitutional issue? Is it a United States constitutional issue? Is it criminal law? Is it tax law? What applies? And when you figure out what rule does apply, then you actually do apply. How does the rule of law apply to these particular facts and circumstances? If you can find a case on point, that's a case that has authority in your jurisdiction, and the facts are super similar, then that's sort of a huge winner for you, because a case on point is very powerful for you, especially if it lends itself to be on your side a little bit. And then the conclusion is whatever the legal conclusion should be drawn. Now, when you do this as an advocate, as an attorney, it may be one-sided, and opposing counsel may be one-sided, but when the judge does it, if there's an opinion, then that creates precedent. If it's in your jurisdiction, and a judge has already done that, you have a case on point, and that's when you can say, Your Honor, this court must do X because this is binding authority in your case. So issue, rule, analysis, or application, and conclusion. Issue, Rule, Application, and Conclusion, IRAC. Again, I point you to page A1. That's the first page in your appendix. There are about 2.5 pages of material there. It's also in Chapter 1 that you're covering. This is key. Once you understand how to do this well, it will change your life. Very easy to say issue, rule, analysis, or application and conclusion. Much more difficult to actually do it. It takes a lot of practice. But once you get that practice and that habit of mind where you look at things this way, it really can be life-changing. It will help you understand what your attorneys are going to be doing if you're in business management or an owner. If you are an attorney, this is what you will spend most of your life professionally doing, is thinking through cases and issues in law and what applies, and then advocating the best you can, writing and arguing orally as concisely and clearly as possible to convince the judge that your position is right.